Good morning, everybody. Each Monday morning, I'm going to prepare a short 5-minute to 10-minute video where I will take you through some of the technical queries that I've received from accountants in the previous week. I'm going to choose queries that I feel are fairly common. I get lots of queries on a regular basis that are very similar. So it would be an opportunity for you guys to have a look, see what the answers are, and a bit of training for you. I'll also then prepare a detailed video on each query that will run through the background, the legal background of what the answer is all about. So each Monday morning, jump onto the Facebook group, have a look, do a bit of learning, and welcome. We're going to call this Advisor's Digest. So today I'll quickly try and cover 4 of the emails I received last week. These are fairly typical emails that I get from accountants all the time, so I think it's pretty good to have it on video to help answer your queries. First one, I won't mention any names. Pete, I hope you don't mind me sending you this message. I have a SMSF with a corporate trustee. Mum and Dad set the fund up as directors and shareholders of the trustee company with 10 shares each. Some time ago, the sons came along and became members. We appointed them as directors of the trustee company. However, for some reason, we did not issue any shares to the 2 new members of the fund. Have we breached anything in the SIS Act? And should we just issue shares in the trustee company to the members to sort it out? The superannuation law, specifically section 17A of SIS, only talks about who the directors of a company must be. There is no mention of who needs to be shareholders or who needs to be the company secretary. So in this case, appointing the 2 boys as directors of the company has completely satisfied the requirements of the SIS Act, and as such, there's nothing that the accountant has to do from a compliance point of view. So that's okay. The next one we have is about establishing a testamentary trust. So trusts could be divided into 2, being inter vivos trusts and testamentary trusts. A testamentary trust, as you all know, is a trust created by will. Person comes along, they've got a will, they've died. The will says, I leave my assets in trust for my children, and Peter's the trustee. The accountant sent me an order form for a family trust stating, here Peter, here's an application for a testamentary trust. I replied and stated that a testamentary trust is actually created by the will and the documentation in the will. So what you do is you look at the will will give you the provisions of the trust. So of course, if it's very basic, then the Trustee Act would apply to most of that arrangement, but some testamentary trusts are quite detailed. They allow the trustees to amend it, they allow them to borrow, they allow them to invest in certain assets. So with a very simple will that just says, I leave the money to Joe as trustee for my children, then Joe really has to look at what's in the Trustee Act to see what he can or can't do. There's certainly no need to come to us for a trust deed or any documentation. You do need to register the trust, you need to get a tax file number, potentially an ABN, and start the trust, but you don't need any documentation from us. The third query was regarding a limited recourse borrowing arrangement, and we all know the problems in these when it comes to potential double stamp duty. This was a New South Wales arrangement, and whenever you're talking about anything to do with state matters, you need to know what state it's in. So we have a fund where the contract of sale was executed 13 May 2016. The security trust deed was executed 27 May 16. So in a way, you've actually agreed to buy the property on the 13th of May 2016 in the name of Bear Trustee Proprietary Limited, and then a week later, you've executed a deed to say that you're buying it on trust for the super fund. The advisor was concerned that the execution date was after the contract was signed and asked, are we able to prepare a deed of ratification or correction to fix this? First, we'll address the date. In New South Wales, the law was changed in around 2014, and they brought in section 62 capital B. And section 62 capital B talks about a trust relationship, and it defines it as being where property is vested or to be vested in the trustee. Now what that means is it can be before the contract or after the contract. That's New South Wales. All the states have specific requirements around dating bare trust deeds. So what we advise every accountant to do when they're dating them is to date the bare trust deed the same date as the contract for the property. So if the law requires you to be before, it could have been just before. If the law requires it to be after, it could have been just after. In terms of correcting the date of the deed, a deed is dated when it's dated and it's executed when it's executed. If you have a deed and you state that it was dated on the 20th of January, but in actual fact it was dated on the 15th of January, sure, you could do a deed of correction. However, if you did date it on the 20th of January, then that deed of correction would be fraud, so it would be illegal to do it. So we would only suggest correcting a date when it is factual that the date was wrong. For example, you incorporate a company on Monday and the deed was dated the Friday before that. Clearly you didn't execute the deed the Friday before. Clearly you did execute it on the Monday. We can correct that because there are errors that are quite obvious because the company didn't exist and you wouldn't have had the ACN before the company was incorporated. And the third one we have is to do with a trustee's incapacity in an SMSF. So we have a situation with a client who is the sole director of the trustee company of her SMSF. She now has dementia and is no longer able to sign documents and make decisions in relation to her SMSF. Her son and a friend have her power of attorney. They're now looking at selling a property which is held in her SMSF, but we want to make sure that everything is in place correctly for them to act on her behalf in this transaction and also for future for the SMSF. Do we need to appoint them as directors of the company, and what documentation is actually necessary for all of this to be effective? Yes, absolutely correct. All you need to do in this situation is to remove the lady with dementia as a director of the company. She can no longer be a director, and appoint her legal personal representative, in this case the son and the friend, as the directors of the trustee company. Because they are the directors of the trustee company, they manage the trust. They can execute documents. They are not trustees as power of attorney, they are just simply the trustees. And you are not breaching SIS by virtue of the fact they have a power of attorney. In theory, you could put me in as the director of that company and we would not be complying with the SIS requirements. However, we would comply with corporations law and trust law. I could go in there, I could sell the property. The only breach would be a breach of the SIS provisions. However, for 6 months, that still isn't a breach. So it's important to understand the difference between a person walking in and saying, I've got attorney for this person, so I want to sign something, as opposed to being appointed as a director or being appointed as a trustee. You need to remove them and appoint the other person. So that's it for today. If you feel you need any more information about any of these queries, have a look at the detailed video or give me a call. If you're not an advisor of the SMSF expert, you can now see one of the advantages of joining us. Thank you.